Okay, perfect. So I think we're good to let everybody in. Okay, awesome. So we'll just give everybody a moment to pop in before we
Hmm.
get started. And like we like to do, some of you have attended these before. If you're not from Alberta, if you'd like to write your location in the chat, we just like to know where everybody is coming to us from, and then we'll get started in a moment. BC, Saskatchewan, Kelowna, also in BC. Yeah, we tend to get a good variety of people from all over for these, so it's always great to know. Okay, perfect. All right, I think everybody is in, so we'll get started.
Keep
Uh,
just checking in case people drop in later. Just every once in a while, have a look.
oh yeah, it shows me when they're coming in, so I let them in. Perfect. Okay, so we'll get started. I will introduce myself. I am Jessica Kirschbaumer, the President and Communications Chair of the Alberta Horse Trials Association, and we are here for another great webinar. I would like to thank the HTA for sponsoring this webinar, and I would also like to thank Kathleen Ziegler for organizing as well. And we are excited to have Catherine Willson here to do a legal look at the horse world for us. And I will just quickly read a short biography of her. She is a founding lawyer of True Law and wrote the Canadian Equine Law Book, available at Self Counselor Press, Amazon, and Indigo. And she also has forms and things available at Self Counsel Press. And she's practiced equine law for over 30 years. She is a chair of the Risk Management Committee and an sorry, honorary governor of the Royal Agricultural Winter Fair. Catherine is a legal expert for the Canadian Federation of Independent Business and Member Services and is a regular speaker at legal and business conferences, an instructor at the University of Guelph, and writes about legal issues for several national publications, including extensive publications in Horse Sport magazine. Catherine also appeared on Canada AM as a civil litigation expert, and she's a rider of bikes and horses, and when not in Toronto, enjoys time at her farm near Collingwood, Ontario. All right, Catherine, so I will turn it over to you, and you can take it away. Thank you so much for being here. We're very excited.
Thank you very much. So we have about an hour, just under an hour, and so I'm going to take you through a whole lot of law, and I'll just touch kind of on the big issues, and then if you wish to drill down, we can do it separately, or you can ask questions at the end, or you can buy my book because it's all in there. So let's first talk about stable owners and operators and how to avoid problems if you are running a stable. First thing is run a safe barn. You need good rules, educated staff. You need to do walkabouts, meaning, and we'll talk about this a little bit later, but semi-annually, every month, every week, walk your barn and see what's safe and see what the risks are. If there are risks, take preventative actions. And you should also educate your boarders and guests on the rules and on what you do to run a safe barn. So, number one, run a safe barn. Number two, use written and clear agreements. I've been at this now for 30 years plus, and if I have one mantra to the horse world, it's put it in writing, meaning boarding agreements, purchase and sale agreements, waivers, If it's not in writing, by the time it gets to my office, it never happened. So put it in writing. And finally, you don't have a business if you don't get paid. So effective follow through on receivables. Now, when I say put it in writing, my favorite mantra, things you can use in a boarding stable include waivers. And for waivers, that's for your riders, that's for your boarders. You might even consider having it for guests if you run a summer camp. Consider it for the parents of the children that come to the camp. Waivers, we'll talk about a little bit further on, but most of your insurance companies now will probably be insisting that you use waivers. Boarding agreements. Boarding agreements identify clearly between the boarder and the stable the rights and obligations that each has. It talks about termination. It talks about what happens if they don't pay, and it also gives you, the rules around what you're doing for the horse. Purchase and sale agreements, so you know what those are. And the other kinds of agreements you might use are leasing agreements where you're leasing a horse, co-ownership agreements where 2 or 3 of you or 10 of you have an interest in a horse. Co-ownership agreements are also called syndicate agreements if you're in the thoroughbred or harness racing world, usually. And there's breeding agreements. I have a number of standard form agreements available with my book at Self Counsel Press. So they come, you download them, they come with instructions, and they're for Canada. And it saves me time because instead of getting requests or doing waivers, reporting agreements, sorry, I can point you to those. Now, waivers are also known as releases. They are an attempt by a riding establishment to limit its liability for accidents, injuries caused to its patrons. Waiver and release forms. Sorry, I've just got something in my throat. I'll be right back. I'm gonna have to get a lozenge. Sorry about that. Let's try that again. So waivers and release forms primarily do 3 things. One, they alert the person signing the forms to the dangers inherent in participating in horse-related activities. As a participant, it would say, horses kick, horses are dangerous, you can die. So it says this can be an at-risk, high-risk sport, possibly. 2, if someone does become injured, it discourages them from suing you because they look at the waiver that they've signed and they said, I've released my rights. If they take the waiver to a lawyer and it's a good waiver, the lawyer will also say to them, you probably won't be successful in court. So it discourages litigation. Number 3, if you are sued and if your waiver is valid, it provides a complete defense or can provide a complete defense to liability for injury or death of a participant. The court must be satisfied that the statements in the release were brought to the attention of the person signing it. By that, I mean use highlights and initials or things of that nature. If you're a skier, sorry, if you're a skier and you're asked to sign a waiver, very often you'll have to initial parts of it, or you'll have to, they'll highlight parts of it, or they'll put them in boxes. If you're a rock climber, if you do any kind of outdoor sport or indoor sport, and you're asked to sign a waiver, you will note that in the parts that are very important, you can die, you're signing away your rights to sue, They will be highlighted, bolded, so they're brought to your attention. A court will only enforce a waiver if an objective observer would expect to find such a term in the document. What we mean by that is the terms of your waiver have to be reasonable and fairly normal. There was a case where people were renting a car, and on the waivers on the car rental form on the back, it said, and by the way, you can't drink any alcohol while driving this car. No alcohol at all. That wasn't normal. So there was an accident, someone had had a glass of wine or something like that, and the car leasing company denied coverage under its insurance. The court said that was not a normal term in a leasing document for a car, and we wouldn't have expected it. We're not going to enforce it. Minors, meaning people under the age of 18, are not bound by a written waiver, but their parents or guardians who sign it will be. What does that mean? It means if a child is hurt, they can't sue you until they come of age, but they can't be bound by that written waiver while their parents can. And then you've got to consider the circumstances around the signing of that waiver, meaning if your rider is on a horse and you pass up a board and say, sign this, the court's probably not going to enforce it because the person never had the chance to read it. They have to be given a chance to read the waiver and then consider it and sign it. Do you want your staff to tell them about the waiver? Consider that. Will it always be the same thing that your staff will say? Or do you simply want to say, here's a waiver, take your time, read it, and sign it? Boarding agreements. Again, identify what the agreement is. It's a boarding agreement. Put in the description of the horse or horses. What are the terms? Meaning, how much are you paying? Is it a monthly fee? Is it a weekly fee? And what's the term of the agreement? Is it week to week? Is it month to month? Is it for 1 year? What are the services being provided? Do you provide turnout? Do you provide feed? What services do your boarders provide? If they do provide services, are there special instructions for the stable operator, such as my horse needs boots when you turn it out? My horse needs a blanket when you turn it out. Are there special rights of the stable operator? Do they get to use your horse in lessons for a reduction in the board? What about risk of loss and injury? Whose risk is it? If your horse as a boarder kicks someone in that stable, the agreement should make clear that it's the boarder's responsibility. The agreement should say the boarder must have insurance covering liability on that horse. And the agreement may also say, if your horse is injured while in our barn, it is not our fault. You, the boarder, assume all the risk. Liability insurance, emergency care. Make sure you have a clause in your boarding agreement that if the horse colics or needs some kind of emergency treatment, you as the stable operator can call the vet, get the vet in, and the boarder promises in the agreement to pay those costs. Because you don't want to have to find the boarder to get permission to call the vet in an emergency situation and then argue over the bill. So have an emergency clause in the boarding agreement. Have in there who pays the expenses. Often there's a barn vet that comes in and does the worming and does the vaccinations, etc. And you would put in your agreement that the vet will invoice and you're obligated to pay the vet. Rules of the barn. Good barns have rules, and they should be attached to the boarding agreement so that they have them and agree to them. Default provisions. If they don't pay their board, what happens? Can you terminate the agreement? How much notice do you have to give them? Can you keep the horse? And we'll talk about that later. And then it should be signed. What are the responsibilities of stable owners and operators to the people and the horses in their care? In general, the responsibility, the standard of care owed to people and horses is reasonable care, meaning you have to, what is reasonable for the industry, in the industry that you're in, so that you have to provide reasonable care to the people and horses at your property. Importance of walkabouts. I like to do a semi-annual walkabout, like 2 times a year, walkabout of my property. And what I'm looking for is anything that can go wrong, anything that can hurt people or animals in my property. So, for instance, look at the traffic in your barn. How do your horses move from the stalls to the arena? Is it safe? What about traffic in the arena? What about the arena door? Do you knock on the door and yell door? Or what are your rules for arena use? How many horses do you allow in the arena at one time? What about tacking up, untacking? So you have traffic rules. Look in the stalls. Every stall should be checked at least twice a year for nails, holes, uh, 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 depressions, to make sure that they're safe. Also, consider things like your feed room. Is it boarded off so that horses, if they get loose, can't get into the feed? Are people allowed to go in and feed their own horses? Who has control over the feed? Consider children. Are children allowed to run around your stable while their parents are grooming the horses and riding? Here's one. Should children wear helmets when in a stable at all times? Uh, just because they're around the presence of horses. Summer camps in my day, we very rarely wore helmets. We didn't wear helmets when we picked the horses up from the fields. We didn't wear them when we walked them in. We didn't wear them when we groomed them. We didn't wear them when we were in the stalls. I would say now, with children, and the fact that we wear helmets to ride bikes, we wear helmets to ski, we wear helmets for, whitewater rafting. I think now children should be wearing helmets, especially summer camps, situations like that. If they're anywhere near a horse, why not put a helmet on the kids? Helmets are so much more comfortable these days, and they'll keep the kids uh, much more safe than if they're grooming a horse without a helmet. Think about dogs. Can your boarders bring their dogs? What does that mean? If you're riding outside, if you have an outdoor arena, indoor arena, what about cars? Cars and horses interacting in parking lots. What about outdoors? Are your paddocks safe? Are your gates secure? If a horse gets out of a paddock, can it get onto a road? In the summertime, if you have the doors open of your stable, can the horse, if they get out of their box stall, wander up the road and get out into a highway? So think of how about ponds? Say you have a pond on your property and you have a bunch of moms who ride, who bring their kids up. Is there a possibility that a kid could wander into the pond and drown or pool and drown while their mom's tacking up the horse or riding in the arena? So look at your whole property from the eye of a child, a dog, a guest, a boarder, people that don't know horses. And if you see problem areas, fix them. If you write that down twice a year and the things you fixed and you put it in a folder, whether it's, a paper folder or a computer folder, if you ever have an accident on your property, and of course they are wondering whether the court will be wondering whether you run a safe barn or not, and whether you're responsible for this accident. If you can show them that you go out regularly to check for problems on your property, and if you see them, you fix them, you automatically have credibility with the court that you are thinking about safety and you're doing everything you can to be safe. So that's a good reason for a walkabout. Rules of the barn and safety protocols. Again, you need those. What are safety protocols? If somebody gets hurt, do you have somewhere in your barn all the numbers that have to be on the phone? Do your staff have training in first aid, CPR? Do you have again, feed rooms being protected? Do you have emergency numbers for all of your boarders? So what are your safety protocols? And remember this, a stable owner is not an insurer for the people entering their property. Okay, you don't have to guarantee people's safety. You have to simply take the reasonable amount of care, a reasonable amount of care to keep them safe. Reasonable is different for different things. The degree of care a horse barn would take may be very different than the degree of care that a ski hill has to take, or the degree of care that some other kind of industry has to take. So it's industry specific too. You have an occupier's liability Act in Alberta. So do we. I'm from Ontario. In fact, most places across Canada have occupiers liability acts. And what they say is that a stable owner or operator owes a duty of care to the people entering the property. The duty is to take such care as is reasonable to see that persons entering the premises and the property brought onto the premises by those people, could be a car, could be a horse, are reasonably safe. This duty does not apply to risks willingly assumed by people entering the premises. In that case, you have a duty to not create a danger with the deliberate intent of doing harm or damage to the person or his property, and not to act recklessly. So what does that mean? Again, let's use waivers. But if someone comes onto your farm to willingly assume the risk of participating in horse-related activities, then the duty you owe is simply not to cause intentional harm or act in a way of reckless disregard for the presence of that person and his safety. Okay. And you're free to restrict, modify, or exclude this duty of care through the use of a written waiver. Accidents. If there is an accident at your property, you should have established an action plan and protocol already. And this is how we were talking about safety features. Emergency telephone numbers should be visibly posted, first aid kits and other safety items available, safety and first aid training for staff. Do a written accident report. I don't care if it's a horse or a person that's injured. You should do immediately after the accident occurs a written report. What happened? Who was there? What do the witnesses say? Time of day, weather, everything you can think of that would be relevant, and file it away. So I've got witness statements, photographs, videos, and the next thing you should do when the person's in the hospital or the horse is safe, everything is settled down, call your insurer, because insurance companies want to hear immediately when there's an accident. If you wait too long, meaning a few days, a week, you may not be covered under your insurance. They want to know right away so that they can bring someone in to assess the issue as well. Okay, and then follow up. In Alberta, as in many other provinces, there is legislation important to the horse industry. We've talked a bit about the Occupiers Liability Act. I want to talk on two other statutes now, the Animal Keepers Act and the Sale of Goods Act. The Animal Keepers Act is an interesting one. It provides a lien on an animal and its gear for the debt incurred in relation to the animal and gear. So, if a horse is boarded at your stable and the boarder has not paid you for a month, 2 months, 3 months, 6 months, you have a lien on that horse and its saddle and tack box and other gear for that debt. The Act provides a mechanism to sell the horse and its saddle and its gear by public auction or in any other commercially reasonable manner. So you can keep the animal, meaning if they haven't paid you for 3 months, they can't show up with a trailer and take the animal off of your property. You have a right to keep the horse until you're paid, and you have a right to sell that horse for the money that you're owed. There's similar legislation to this across Canada. In addition, the common law, which is the judge-made law, also provides you with a lien. And interestingly enough, if you're into the breeding, the lien doesn't just apply to a mare, but it also applies to its unborn foal. Horses are usually sold by auction after written notice is given to the boarder or the owner. The sale proceeds first pay the outstanding board, and any remaining proceeds go back to the boarder or usually there's very little left with these auctions. The Sale of Goods Act. This works with purchase and sales. And I told you that it is very important to have a written agreement for a purchase and sale. This is one of the reasons. The implied warranty of fitness for a particular purpose. In short, if you regularly or routinely buy and sell horses, then if a purchaser comes to you and says, I want a horse that can jump 3 foot and is good with kids, you can just point at a horse, they can buy the horse. And if that horse is not able to jump 3 feet and be good with kids, then you have breached the implied condition of sale that the horse will be fit for a particular purpose. Meaning, if your purchaser says to you, I want this horse for this particular purpose, you're responsible to deliver that kind of a horse. The normal rule is something called caveat emptor, buyer beware, where the purchaser will come to you and say, I want to buy a horse. You say, here's a horse. You say nothing else. You make no representations about that horse. They buy it. They take it away. They bought the horse. Doesn't even matter if the horse is found. They bought the horse. But the Sale of Goods Act says, if your purchaser says that I want a horse for these reasons, and you are in the business of buying and selling, or you routinely buy and sell, then there's this implied condition. You can negate this implied condition in that purchase and sale agreement. The seller can write in the agreement, the implied condition of fitness for a particular purpose does not apply to this horse deal. Okay? So that means any representations the purchaser makes to you don't count. The other reason, by the way, for a sale agreement is the old arena discussion, where you're in the arena and you're riding around on the horse and you're talking about the horse. And in that arena, or when you're tacking up, things are stated about that horse, about its character, its condition, its abilities. When you purchase the horse and bring it home, none of that was written down in a sale agreement, but you relied on it in making that purchase. If the horse doesn't live up to those statements, then you're going to want to return the horse. You're going to want a reduction in the price. But I can promise you, the seller will not remember making those statements at that time. So if it's not in writing, it never happened. So as a purchaser, if there are things said about a horse that are important to you, make sure it's in a purchase and sale agreement. As a seller, if you want to make sure that no statements you made can come back against you, or even that the purchaser heard you say something that you never said, you can put in the purchase and sale agreement, this is the entire agreement between us. No statements, representations, etc., made outside of the four corners of this piece of paper matter. Just what's in this piece of paper are the terms of sale. That protects the seller. So there's a very good reason to have a written purchase and sale agreement. The Sale of Goods Act also deals with trial periods. So for a trial period, the seller gives the horse to the buyer for a month and says, try it out. Well, during that trial period, the property in the horse does not transfer to the buyer. It remains with the seller. So if the horse is injured during that month's trial, that's on the seller. The buyer can just give back the injured horse and say, sorry. It's not until the buyer signifies approval or acceptance to the seller, or until the trial period has expired without the buyer giving notice of rejection, that the property in the horse may transfer to the buyer. Okay, so be careful with trial periods. And again, if you have a written agreement that says, I'm going to give you my horse to try for a month, but if my horse is injured in that month, buyer, you own it for this price, you're protected. Transfer of risk. This is also part of the statute. The horse remains at the seller's risk until the property and the horse is transferred to the buyer. Once transferred, the horse is at the buyer's risk. An example of this would be that the buyer pays the purchase price, everything is signed, it's the buyer's horse, but the horse stays with the seller for a week while you arrange transportation. Well, until it's transferred to the buyer, it's the seller's risk. Now, what does transfer mean? Property passes from a seller to a buyer at such time as the parties intend it to be transferred. So in that situation, did the property of the horse pass when the money changed hands, when the buyer shook hands and left, or when the horse got on the trailer? Put it in writing. Okay, otherwise the judge is going to be looking at, well, when did the property transfer? Who owns this injured horse? Delayed payments. If a contract is oral, meaning it's not in writing, and the horse is not immediately being delivered into the buyer's possession, then the seller must obtain, at a minimum, a down payment from the buyer. If you do not, then the seller will not be able to enforce the contract if the buyer refuses to pay the sale price. Okay, that's something I bet you didn't know. Delayed delivery. If the seller must do something to the horse to put it into a deliverable state, the risk does not pass to the buyer until such a thing is done and the buyer has notice of its accomplishment. If the horse is injured or dies during this period, the seller bears the consequences, even if the seller has the buyer's money. What's an example of this? You, as a buyer, bought the horse, but you're leaving it with the seller for training for 3 months. You paid the money, you bought the horse, but it's with the seller for training for 3 months. During that time, the horse is injured or dies. Risk does not pass to the buyer until the training is accomplished. So again, a written agreement can clarify all of this and undo these deemed assumptions from the Sale of Goods Act. Let's talk a little bit about employment. Some of you who are running barns will have staff to assist you on the barn. So let's talk about hiring and firing a little bit. When you are hiring somebody, the human rights codes, again present in pretty much every province, require you not to ask certain questions. You cannot ask about age, date of birth, hair or eye color, weight or height. You can't ask about religious affiliation or Canadian citizenship. And you can't ask for Miss, Mr., or, like maiden names or greeting identifications. When you offer the job to somebody, you can then say, I want to see proof of your Canadian citizenship, or some of the other things you're not allowed to ask at the outset, but you can't ask when the applications are coming in. Now, when you hire an employee, again, put it in writing. It is always a good idea to have an employment contract with your employee. It sets out the compensation, whether they're paid weekly or hourly. You could set out their job description, and you can also specify that you're allowed to change the job description without that being considered wrongful dismissal. There's usually a probationary period in which you can dismiss them without providing them with any pay or notice. The ability to lay an employee off is important. Sometimes you can only lay them off if it's a contractual term that they agree to. This became very important when the COVID-19 outbreak occurred. Termination provisions are important. How much notice do you have to give an employee to terminate them? If you have a long-term employee, 5 years, 10 years, 15 years, you could find yourself paying 5 months to 2 years salary when you terminate that employee as common law notice for that termination. People are very surprised about that, but it could be up to 2 years of salary you would have to pay a terminated employee who worked for you long term. An employment contract can reduce that considerably. Non-solicitation clauses are important in our industry. If you have an instructor that works for you as an employee, if you and your instructor fall out, that instructor could move to a new barn and take half your clients. If you have a non-solicitation clause, then that instructor can be prohibited from soliciting your clients and removing them to a new barn. Confidential information is important to you as well. Your names of your clients, their addresses, other information, you could have that. And one other thing, if you are signing an employment contract, for all contracts, there has to be a give and a get. For the purchase of a horse, you give them the horse, you get the money. In an employment situation, you're giving them a job, they give you an employment contract. If, for example, you say to somebody you want to hire, we're hiring you, come in on, you start Monday. They show up Monday to their new job and you say, welcome. First thing I want you to do is sign this employment contract. That employment contract is probably not enforceable because you've already given them the job. So what are you giving them to get them to sign the employment contract and give away some of their rights? Nothing. So make sure the employment contract is part of the offer. If you have employees without employment contracts, you can have them sign employment contracts if you give them something. Could be a raise, could be a bonus, but there has to be a give and a get. Job offers, we just, I think, spoke about this. Avoid making a verbal job offer without the written terms. Okay. And when you do give them a contract, make sure they have time to review the contract. Hopefully in your employment contract, it also says, please feel free to get legal advice. The courts always like to see you at least encourage an employee to get legal advice before signing a contract. Normally they won't, but it's nice to see it and make sure they're signed before the work starts. If you have independent contractors, so these are not employees, these are people that you pay, they invoice you at the end of the month. There could be, provincial sales tax and or services tax, and you pay them monthly or you pay them weekly depending on their hours. So you don't remit CPP or EI. They're not a salaried employee. They are a contractor. Maybe they work for you and some other people. How do you tell the difference between an independent contractor and employee? Let's back up for a minute. Why is this important? It's important because the Canada Revenue Agency may come into your stable at some point and say all of these people that you're paying as contractors are actually salaried employees. And if they deem that to be the case, they can go back 3 years and force you to pay your remittances to the Canada Revenue Agency for those people that have been working for you, which can be very expensive. So how can you tell if you have a contractor versus a salaried employee? One is the control test. How much control and direction do you have over a worker? Two is ownership of tools. Does your worker own their own tools or do you own them? Three is a chance of profit, risk of loss. Can they make more money or lose money? Is it within their control or is it within your control? And finally, the organizational test. Is an individual's work an integral part of the business operations of the company? Examples would be if you have an instructor that teaches at your barn, but also teaches at two other barns, I would call that person an independent contractor because they are basically, they're working for a number of parties. If they use anything, they use their own tools. Their chance of profit or loss depends on how hard they work, and they're not an integral part of your business. Same with a farrier. But if you have someone that comes in 4 days a week, part-time to muck out stalls, and that's all they do, they could be a salaried worker or an employee versus a contractor. Dismissal. When you dismiss an employee, there are two ways you can dismiss them. For just cause, meaning they've stolen from you, serious misconduct, gross incompetence, insubordination. Normally you issue warnings. You can, and if you fire someone for just cause, you don't have to pay them termination pay. That's a very rare circumstance. Most terminations are done without just cause, meaning you have to give them notice that you are terminating them. I'm going to let you go from this job in 1 month, 2 months. Or if you're not going to give them that kind of notice and you let them go Friday, you have to pay them in lieu of that notice. We're letting you go Friday, we're going to pay you 2 months of your salary. What is reasonable notice of termination? The Employment Standards Code in Alberta, in Ontario, and BC is a minimum standard only. The judges, the court-made law, has increased the amount of notice or pay in lieu of notice that you give to an employee with, based on factors such as their age. The older they are, often the more notice you have to give. Seniority, how long have they worked for you? Someone that's worked for you for 2 years will be getting less notice of termination than someone that's worked for you for 10 years. And your position. Are you a vice president? Are you a teller in a bank? Because theoretically, the lower you are in the totem pole, the easier it is for you to get rehired. What is reasonable notice of termination? It's a ballpark that the courts will assess based on all of these factors, remembering that the Employment Standards Code is a minimum. Another good reason for an employment contract is you can restrict the amount that you pay an employee on termination to what's in the Employment Standards Code. Also, and for the horse world, this isn't a big one, but consider pension, benefits, and disability. Something important in the horse world, what happens if the person that works for you is injured at work? Do you have insurance that covers employees and contractors and volunteers that work for you in case they get injured? What about workers' compensation? You could check in Alberta, in Ontario, certain horse farms are mandatorily covered under our workers' compensation. Other horse farms can opt in for a WSIB coverage. The beauty of workers' compensation coverage is an injured worker can't sue you because the system looks after them. So it stops lawsuits from your employees. So I would check if you have a big enough, a big enough establishment. I would call your workers' compensation board in Alberta, find out if you're, as an employer, required to have coverage. You may be. If it's optional, how much would it cost for you to get it? And I would also put a call into your insurance company for your volunteers, for your employees, and for your contractors. Are you covered? Because your insurance company would probably cover your boarders, your guests, but sometimes they will not cover employees or people that work for you, and you don't want to be surprised. Let's talk about veterinarians. Veterinarians have obligations to their clients in both contract and in tort. By contract, you pay them, they come out and deliver a service. That's a contract, a give and a get. And by tort, I mean negligence. They deliver a service, they do it poorly, the horse is injured, that's negligence. What is the standard of care for a veterinarian? Same kind of thing as for a stable operator. A reasonable degree of learning and skill ordinarily possessed by practitioners in similar communities in similar cases. So if you think your veterinarian was negligent, if you take that vet to court, they will be judged by the standard of care that veterinarians looking after horses in a community like yours, most likely in Alberta, would give. So so the standard of care may be slightly different somewhere else in Canada than where you are, but that's what they're looking at. Normally, you would have an expert come in and say, a veterinarian should have picked this up. This is something they should have done. Yes, this was negligent. Tips to avoid problems with veterinarians. When you're doing a pre-purchase exam for a horse or when you're getting one done, provide clear instructions. Make sure your vet tells you what tests are available, what tests will they perform, and you want to have communicated to your veterinarian any known histories of the horse. Why do you want to know what tests are available? Because maybe you want ultrasounds, maybe you want x-rays. You should at least know that they're available. What about blood work? In Ontario, the practice seems to be that a veterinarian will take blood work, but won't run that blood work for a month or two. And if they don't hear from you after that, they get rid of the blood. What is it in Alberta? Do they automatically take blood? Do you have to ask for it? How long will they keep the blood? And for the purchaser, it's important to know the history of the horse. Ask your vet to make inquiries of the seller for the history of that horse. Get your results in writing. Don't rely on oral results. Watch for conflicts. Is the veterinarian that is pre-purchase vetting the horse the vet for that barn? Meaning that vet has a history and relationship with the seller over a long period of time? If so, that vet could be placed in a conflict because the vet might know something about that horse that happened 5 years ago, but he may not want to disclose it because they worked for the seller and it's confidential, but he's vetting it for the purchaser. There could be conflicts. For general barn services, again, this is where the beauty of a boarding contract, you can write in there into your boarding contract who's paying for the vets, who's ordering the vet in for routine things, what happens in emergencies, as we talked about, and you can be clear with your boarder on who's footing the bill for each of these. And then you can follow up and ensure payments have been made to your veterinarian. Let's also talk briefly about the business of horses. Assuming some of you are in the business of horses, it can take a few shapes. If it's just you and your horses and a bank account, it's a sole proprietorship, meaning you are in the business, you hopefully have opened up a separate account and you run your horses in and out of that bank account. You've got a business plan, you're running it to make a profit because remember, the purpose of a business is to make a profit. You can't be running a business if all you're doing is losing because you'll be reassessed and Canada Revenue will say this is not a business. So you can be a sole proprietorship, which is one person and a bank account, and off you go. A partnership is two or more people who are in together the business. So, for instance, you might buy a horse with a friend, and that's a partnership. And if you bought that horse to train and sell for a profit, that's a business. And maybe you're going to do it to another one and another one and another one. What's important with sole proprietorships and partnerships is a flow through of income and losses. If there is money made on the horses, it goes on your personal tax returns. It's a flow through. If there's money lost on the horses, you owe it personally. You and your partner. You and your partner would be jointly and severally liable for those losses. There's a business vehicle called a limited partnership. We don't use that very much in Canada. In the US, they have different rules, and you'll see a lot of limited partnerships in the horse world because they have different rules. Finally, here we use incorporated companies. Companies have Inc. or Limited after their names. And if you have a lot of horses, a lot of risk, or you're making a lot of income, you would consider incorporating a company and running your business through a company. A nice thing about a company is it's like another person. So it is taxed separately from you. And if there's a loss, it's the company's loss. You're protected. Business tips again, put it in writing. I keep saying this, but it works for everything. If you have a partnership, make sure you have a written partnership agreement with your partner or partners. Think about the details. I can tell you, I've had cases where we've had, 10 people buy thoroughbreds and one dies. What do you do with their share? Or they want out, but there's no written document about how you get out of this thing. Or the horse is losing money and six of you want to put in another 100 grand and the other four don't. What happens then? And how do you dissolve it? Do you have to sell the horses? Put it in writing. There should be a dispute resolution clause, meaning if you guys are arguing, there's a way to settle it, be it mediation, arbitration. You have a ultimate person who's going to resolve the dispute. An escape clause. By escape clause, I mean a termination clause. If somebody wants out, how do they get out? How do you blow the thing up if you want to blow it up? Who gets the horses? Are they sold? So an escape clause. Have a financial planner. These all have tax consequences. So know those tax consequences. You're going to have to file taxes if you're running a business. So have a financial planner. Plan ahead. You want a 3-year plan, you want a 5-year plan, and make it look like a business. There are some advantages to running a business in the horse world, but only if it looks like a business. You don't want, again, Canada Revenue Agency to come back 5 years from now and say, all those losses that you deducted, you never had a chance. This was never a business. It doesn't look like a business. You didn't run it like a business. This was a hobby, and you owe us this money. Receivables, getting paid. We've talked about the liens under the Innkeepers Act. There's also a lien for stallion fees. You can keep the mare and the unborn foal if you have not been paid your stallion fees. In addition to the liens, which only work, by the way, if you've got the horse. Once the horse is out of your care, you've got no more lien. What are you liening? And you can't sell a horse because you don't have it anymore. So keep the horse in your care until you're paid in full. You can go to court. You can start a legal action. In Alberta, there's small claims courts. In Ontario, the small claims court's up to $35,000. And it's very easy and it's meant for people, not lawyers. And you can do it yourself, or you can hire a lawyer to kind of help you along the way, but you can still do it yourself. In a bigger action, you need lawyers. Procedures in a legal action, they're painful. Legal actions are long, slow, and expensive. Better to avoid them altogether. How do you avoid them? By putting your transactions in writing. Because if they're in writing, it's very unlikely that there is a dispute. And if there is a dispute, often you're going to know who's going to win. Okay? If you don't want to sue, you can mediate, where you get together with an experienced facilitator or mediator who is skilled at getting people to an agreement, the just say yes philosophy, or getting to yes, I think it's called, where it's interest-based negotiation sometimes, and very often they can help you resolve a dispute by agreement. You can arbitrate a dispute where you don't go through the courts. You pick an arbitrator who you pay almost like a private judge, and you can go to arbitration. I put police involvement here because very often people call me and say, "Oh, they won't give me my horse. Should I call the police?" Or, they're keeping my tack, or we're having this, there's people, they're showing up with a trailer on my property. Do I call the police? And 90% of the time, you can call the police and they don't get involved. They will tell you this is a civil matter. Go hire a lawyer. So, is police involvement something to do sometimes? Depends on the situation. Most of the time, I find the police don't want to get that involved, and they'll say, look, this is a disagreement. It's a civil matter. Go hire a lawyer and figure it out. And that's really all I have to say. Those are some of the issues that are important to horses. I haven't touched on wills. I haven't touched on and what happens if you die and you have animals in your care. We haven't talked about divorce and who gets the horses. We haven't talked about breeding, care. There's a lot of other issues that I do talk about in my book. So that's something you might want to think about. And the forms again are at Self-Counsel Press if you're interested in buying some of these forms, or hire a lawyer and get that lawyer to help you with them. I think I'll stop there, and if there are any questions, I'll be happy to take them.
Wonderful, Catherine. That was amazing. That's a whole lot of information that I'm sure lots of us sort of know about, but have never really thought about. If anybody has any questions, feel free to pop your video on and ask them, or you can also put them in the chat. I have a question. Um, where do working students fall? Um, you were talking about sort of coverage for employees and volunteers, like in the waivers and things. But if you have a working student that's saying not getting paid for their um, work, but compensated in other ways, where would that fall under?
Well, again, that's a contract, right? Because it's a give and a get. You are giving them lessons and training them and not charging them. And in exchange, they are giving you their services in assisting with the chores around the barn. So it is a contract, it's a give and a get. And are they employed by you? No, they're not, they're a student. I would say the two things I would tell you to do is one, tell your insurer, I have working students. I teach them riding and train their horses and they muck out stalls or whatever it is. I want them insured. So they should be insured. So that's one. And two, I would call your workers' compensation and say, it's almost a barter. This is, I've got a working student. Uh, is that something that we need to include in the workers' compensation or not? Okay.
Yeah, excellent, thank you. So, like, you just have to declare it and sort of just know where it stands, not
Yeah,
just doing it and assuming it's fine.
in simple speak, you need to protect your property, your business, your livelihood from a lawsuit in the event of an injury by anyone that comes onto your property or damage to a horse, whatever it is. So property. So that's the simple speak. So how do you do that? You have a safe barn, you have written agreements, you have waiver forms, but this is safety net on safety net on safety net. And the ultimate safety net is if someone sues you, who pays? Are you going to lose your house or are you covered by insurance? Are you going to lose your house or is it workers' comp? And these are different animals. The boyfriend of the woman that comes on to watch her ride and gets hit by a car or a horse is a different person than the rider, a different person than the kid, different person than the working student, different person than the groom. These are all different animals. So you have to think what kinds of people are coming onto my property and make sure that if you're inviting them onto your property, if you're permitting them onto your property, that if they get hurt, you don't lose your house. That's it in simple speak.
Mhm. Perfect, thank you.
Okay.
We have a couple comments in the chat, a couple of thank yous. Very interesting, and thank you for your expertise. And then we also have a question from Megan. She says, I'm a farrier student and was wondering what are the rules or laws around farriers? How can farriers protect themselves legally from being sued?
Okay. Well, hopefully, you being the farrier, you would know the laws and the rules better than me. But again, I'll go back to my mantra, put it in writing. So if you're going to go to a stable and start shotting, looking after their horses, why not have an agreement saying, this is who I am, these are the services I provide, this is how much it costs, these are the risks I'm prepared to accept, these are the risks you have to accept. For instance, if you have a horse that has bad character, that is known to kick or bite, I have to be informed. You have to tell me of the horses that could be a risk to me. So you will have a written agreement that your clients will sign that protects you and protects them. Plus, it sets out your pricing. It tells them when they're expected to pay. Hopefully, there's an interest rate. And then when you invoice them, that's all on your invoice too. This is payable within 30 days. After that, it accumulates interest at the rate of 10% per year. So it comes back down to documents. And why documents? Because it allows people to read and understand your expectations, their obligations, and who assumes what risks.
So farriers should have their own waivers and things.
Maybe not a waiver, but certainly
A
an
contract.
agreement with a waiver clause in it.
Mhm.
Yes. Now, does that waiver deal with, if I shoe your horse and your horse is, becomes lame, I'm not responsible? Maybe not. That could be bad for business. But, could there be a waiver that says, what would it be a waiver for farrier? Um, it could be if someone is injured while riding a horse that I've shot, that's hard because they would have to sign that. I'm not sure if there'd be a waiver there for a farrier, but certainly a farrier would have to say, you must identify for me horses that have problems that could hurt me when I'm dealing with them. And if you don't, and I get injured, you're responsible.
Excellent.
Okay.
There was a bit of a follow-up. Uh, to add, should as speaking like as a barn or horse owner, should we also have our farriers sign a waiver prior to working on our horses, especially if they're on our own property?
Well, a waiver for what? What would the waiver be about?
Uh,
Would the waive?
for the horse owner, like that the horse owner provides. That if the farrier is injured by the horse, I guess if they're I think
I
that's what
don't
they're
think
saying.
any farrier is going to sign that waiver. I think if anything, the farrier should be getting the horse owner to declare issues with the horse. And if they don't declare any issues and this horse is a known kicker or biter and the farrier gets injured, then they've got something there. No, I don't think a horse owner is getting a fair because no, is getting a farrier to sign a waiver. No, I haven't seen that and I don't expect that.
Okay. Okay, that's what they were just asking. They just clarified.
Yeah, yeah.
Great, thank you. Um, Another question, is a text message or email considered in writing, or does it have to be an actual document?
Text message or email for what? There's an interesting case that just came out last year where a thumbs up emoji was considered a contract. And it had to do with, I think, the sale of some kind of, it wasn't straw, but some kind of agricultural product. And it was like, oh, are you buying the product? It was all text. And it was like a thumbs up emoji. And was that a consent on a contract? And the answer was yes. But may I say to you guys, if you're thumbs up emojiing your contracts, you've got bigger problems. Okay. Please just put it in writing, send it by email, write it down. Texts are so hard to deal with in court. They're difficult things are misunderstood on text, right? Something you write that's completely innocent can turn around and mean something else several different ways because they're so short. So for something important, people's health, safety, a horse that you're buying or selling, these are expensive things. It makes sense to do it properly.
Perfect. All right. Oh, I had this thought earlier when you were talking about selling horses. Um, is including like as is in the bill of sale something recommended, or does that not matter? Or
Well, this horse is sold as is sort of what they're saying. Is
Mhm.
that good enough? Uh, eh, no. So this horse is sold as is. That doesn't help you with the arena conversation, right? Where the pro, not the owner, but the pro is out there going, "Oh, this horse is fantastic, and it's 8 years old, and it's never been lame," and the owner might not even be there. And then the writing says this horse is sold as is. So what does that mean? As is like everything you said in the arena, or is it just what does as is mean? So that's I would say that's not good enough. Because if you had the clause that says this is the entire agreement, only this agreement, anything that was said before doesn't count, and it says this horse is sold as is, maybe it's stronger. Um, it depending on the amount that's at issue and the willingness of the two parties, this could be a huge fight and have to go to the trial judge to interpret, which is why I'm saying get a good contract. And now, I mean, I'm just one person, but at least I've got some forms there that you can download and look at and consider and change. Or, you know, go to your lawyer and draft one yourself and send it to a lawyer and say, will this work? And they'll add their, magic legal speak. But just as is, probably you could end up with problems. What does as is mean if a horse is diagnosed with navicular a month later, for instance?
No, that makes a lot of sense for sure. All right, we have another question in the comments box. Is it appropriate to have a clause in the training contracts as a trainer to the effect of if you find out the horse has dangerous behaviors the owner did not disclose initially? Does the clause, oh, sorry. And for an example, she was sent to mare about 10 years ago that was a known flipper, but nobody told her until she did it. Does that clause nullify the contract immediately, non-refundable?
Oh, yeah, you can put that in there. Absolutely, you can put that in there. Yep. And I think boarding agreements should say what are the problems with your horse? Does it bite? That's something you should disclose, right? These are very serious things that should be disclosed. When you sell a horse, I think you should be disclosing these things. And certainly purchasers should be asking, are there any bad habits or traits that this horse has? So I think that was a big problem. And she's lucky she wasn't hurt. And yes, you can say in there if you here disclose all your horse's bad habits, and if you don't, the money you give me is non-refundable. The horse is going to be returned, and if I'm injured, you're paying for it.
Oh, and she also went on to say, what about lease contracts or people that stand you up and don't pay? She had my first experience of that in December on a horse I didn't own but leased. Oh, sorry. Ah, sorry, I just scrolled past.
Mhm.
On a horse she didn't own but leased for this client from a fellow barn. She stood me up for the entire board and lessons for the month, disappeared, and then snuck into the barn upon return to steal her stuff. And that was a whole new level for her because she's never experienced that before.
Well, these things sometimes happen. Fortunately, not too often. But again, she would have had her remedies under the Animal Keepers Act or whatever it is out in Alberta, the one we looked at. She could have sold that horse by public auction and the stuff if it hadn't been spirited away in the
Stolen
night.
back. Yeah, that's people do weird things for sure. Emily has a question, a specific tax question. Have you seen horse breeding programs for disciplines excluding racing fall under the Income Tax Act's definition of farming. And then she goes on to say the farming definition says it includes maintaining horses for racing. So she's curious if other breeding programs that aren't for racing can fall under that, if
Yeah,
there's
is it?
still substantial profits from selling those horses.
Yeah, the breeding and maintaining of horses for racing. So it's breeding and maintaining of horses for racing that ends up under farming. Farming also includes livestock. Our horses, livestock. Uh, right now, courts are kind of saying no, especially sport horses. If you're a stable operator, you're not impacted by Section 31. Are you impacted by Section 31 with a dressage horse? Um, right now, we're trying to say no. No, and I'm going to say no, probably not. But is it livestock? That's the only thing you're going to end up with, or the breeding and maintaining of horses for racing. Now, I think you're okay if you're in dressage, but it's very hard to prove that you're a business. Uh, so you have to, and that's the big, are you a hobby or are you a business? I have a whole seminar on that, which is too much for today because it's complicated and you'll get me ranting because Section 31 on farming is the most unfair piece of the Tax Act in Canada, and it kills farmers and it's killed our racing industry. And the fact that we have anything is amazing. I mean, farmers in Saskatchewan, there are Hansard reports from Ottawa where, there's been a downturn in the economy and farmers end up driving school buses to pay their mortgages and for all their big farm equipment. And they have to do that for 4 years. And because the school bus income is larger than their farming income, because their farming income is negative, it's in the tank, that all they are losses, and they're claiming the losses. Revenue Canada will reassess them and say basically, you're a hobby farm and you have to pay back all those losses, even though you were paying taxes as a farmer for 15 years going before. And they've bankrupted many a farm, this piece of legislation. So there's a chapter in the book on this, but it's a whole other discussion.
Oh, that's pretty crazy.
Yeah.
Yeah, and definitely frustrating.
Yeah. If you are caught under the definition of farming, for those that don't know, you are limited, if you are running a business, you are limited to declaring losses totaling $17,500 a year. So you could put $500,000 into your horse business in a year, and yet if you suffer losses, you are limited to $17,500. You could take that $500,000, put it into a restaurant, lose all of it. It's 100% deductible against other income. Only in farming can you not do that.
Oh,
Yeah.
yeah.
So I'll stop there.
Oh, Emily asked, and you might have just explained it. Could I actually have that information in that farm tax segment? She's a law student interested in agribusiness and tax.
So there are articles by me on the internet. I think one was called Stephen Harper Hates Farmers because he changed the act to make it even worse. And there's a chapter in my book on it.
Perfect. And could Emily contact you maybe for more information on that? Or you could get like direct her to
She can
more
she can buy
resources?
my book. She can buy my book because it's not very expensive and it explains it better than I will. And just to one other little point on this,
Mhm.
the section was actually the very first thing in the Tax Act that allowed people to deduct losses from one business against income from other businesses. And it was to promote farming, gentlemen farmers. And then it got flipped on its head, misinterpreted, and it went from being a blessing to a curse.
Sorry, can I just ask the question, I guess, like a little bit better structured regarding the leasing?
Mhm.
Right. Yes.
Okay, so the issue that we had was it was a horse that was borrowed from a different facility. The girl didn't own the horse, didn't have any legal rights to the horse, but she had a signed contract. She had upgraded to a full lease. Now, my mistake was not getting a re signed contract saying that she had upgraded to a full lease. But when she left in December to go home to Ontario, my bill was basically ignored till the 10th. And the agreement that I left with the owner was that I would cover the board bill and like lease the horse from me to her because I worry about this exact situation and I would never want to be an owner knowing that, my horse had the Livery Keeper Act pulled on it when it's not her horse to sell. So like do you have grounds if your contract is clear enough or say like lawyer approved that you could try and take that person to small claims court or something?
Sorry, take which person? The lessee that didn't pay you?
The lessee that didn't pay because you don't have anything against her unless she leaves her stuff and you can get it before she picks it up. Now, I didn't know she had a locker rented at the barn at the time. So she was able to sneak back in and get her stuff within a 3-day window at the end of the month, and nobody knew she came.
And,
So we couldn't
and
hold her
it's
stuff.
that's a lot of details, but I guess in simple terms, uh, if you have a contract and the lessee owes you money under the contract, of course you can sue in small claims court.
Okay. I have no experience with the small claims court, so I don't even know what it costs, but it is something that I think I would like to
Uh,
keep in mind for future.
yeah, in Ontario, it's $100 to start an action. I think it's 150, and you can do
Oh,
it
that's not
yourself.
bad.
Yeah, and it's all online. Everything
Okay.
is online. You don't even have to show up in court. I don't know about Alberta, and if the person is in Ontario, you might have to sue her in Ontario, but it's all online. One good thing about COVID, at least in Ontario, our courts are online for the most part.
Right. Well, she's back in Alberta as far as I know. It was just more the fact that like I've never had I've had people try to get out of an agreement like that and not give you notice, but this was just beyond for me. And I felt bad for the owner and I just told her flat out that I had covered the bill because I didn't want to put that back to her.
Well, if as long as you've got the contract that says you're right and they're wrong, it's cheap, cheap, cheap to do a small claims court action, and it'll make you feel better.
Okay. Okay. So then that means that every time that person, say, moves houses because this girl rented, and I know she moved twice during the duration of her lease, I'd have to get a new lease contract every time because it would have to be current address, etc.
No, no,
No.
no.
So I
Uh,
could still go after her right now.
yeah, just because she changes her address doesn't change a contract
Okay.
or
This is good to know.
contracts. We wouldn't have very many valid contracts.
Well, that this is what I was trying to figure out. I'm trying to figure out what would nullify that contract that I could not go after her. Now, the only thing is it was not clear. Like the contract basically stated that this girl was only half leasing. She upgraded to a full lease. We did not change the contract to that. So I'm not sure if I could go after her for the invoice yet.
Well, I can't help you there because you're getting very specific.
Yeah.
So, if you want, you can, retain a lawyer for an hour in Alberta and shove it under their nose and get a little bit of quick, have them look at the contract and answer your questions and then go and do it yourself.
Okay. No, that's awesome. Thank you. That answers my question.
Okay.
All right. We have another question in the comments. Would farrier responsibility be similar to vets to provide a reasonable degree of learning and skill in the industry? And if brought to court, would a farrier be compared to other farriers to assess fault? For example, if a farrier claimed the farrier, or sorry, if a client claimed the farrier lamed their horse.
A good question. And yes.
Excellent. Does your book cover what sorts of insurance waivers coaches should have to make sure they're completely covered in every situation? For example, training horses, lessons, or clinics.
The book talks about the book talks about that, but the book doesn't, the templates are separate from the book. So you'd have to go into the templates and look at the waivers. I have 2 or 3 waivers. I'm not sure if I have a waiver for an instructor in the templates. You'll have to look. If
Okay.
not, another place to ask for waivers is from your insurer, because they often have waivers handy and would be happy to give them to you because the waivers protect them too.
And so I can sort of speak to this. I am a coach and clinician, and my insurance does provide a waiver. Would you suggest getting the waiver looked at for the different circumstances? So if I'm having training horses in, or just doing lessons, or if I'm traveling for clinics, or do you think one would cover all of those?
What I do in my waivers is I use a word like horse-related activities,
Hmm.
and I make that a definition. And then I say horse-related activities include, and then I list everything I can think of. And then the waiver relates to horse-related activities. So that's one way you can do that.
Okay. And if, like, when you're getting specific and listing all the things, if something random happens that isn't listed in there, would that come back on you, or would your butt sort of been covered because you tried to list all the things?
You're going to make it so broad that
Yeah.
there is no random thing.
Okay.
Okay.
Excellent.
Something else to consider as an instructor or coach is the safe sport stuff too, right? Our associations and safe sport. You can't contract out of safe sport, right? Or your codes of conduct, right? So that's another twist to this that you have to consider. Not only are you can protect yourself against your clients, but your clients too are protected from you. And there's the codes of conduct and the safe sport policies that everybody should be aware of if you're a coach.
Yeah, that's definitely a big thing nowadays, and that's
Yes, it
important to
is.
note.
Yeah, yes, it is.
All right. One more question. A horse sold as a gelding by a person selling on consignment for the owner, and it turns out to be a cryptorchid. Who is responsible for the potential costs associated with the surgery, the consigner, or the owner? The purchase of sale was signed by the consigner, and the purchase of sale stated that he was a gelding.
Yeah. Too specific. I cannot, that's too specific. I can't give you an answer on that, but I can tell you, I've read some cases about cows and cattle with this same thing and horses. So the cases are out there. And this has happened before, but yeah, it depends on the facts of the case. We'd have to look at the agreements and everything else, you know. What did the consignment agreement say? Chances are the paperwork in that consignment situation deals with that. Okay.
Perfect. Awesome. So, oh, she says thank you.
Okay.
Excellent. Okay, so I'll just give everybody another moment. If you have any other questions or anything for Catherine, please put them in the chat or you can pop on.
Yeah, or worst
Um,
comes to worst, you can go to my website, which is True Law Legal, truelawlegal.ca. And or you can email me, Catherine with a C. There it is, Catherine, at True Law, TRUELAW, truelaw.legal.
Perfect. When I send out the email to everybody who registered, I can include your
Website and
email
the,
in
yeah,
there if
yeah,
they have
or
any
the
questions or
website.
anything.
The
Yeah,
website
and
has lots of articles too, articles that I've written in the past. So you can always go to the website and check out some of the articles that might have something you want to, or just buy the book. The book's very easy to read. It's written for people, not lawyers, and I think you'll find it helpful.
excellent. Right.
Okay,
So yeah. So I will, oh, a couple of thank yous in the chat.
you're welcome.
Excellent. Yeah, so we're probably gonna wrap it up now. I will thank HTA for sponsoring this talk with Catherine. It was very in-depth and informative. And I'd like to thank Kathleen for organizing. And then I'd like to also invite you to our next webinar, which is March 13th. Dr. Sarah Skoteric will be doing a talk on parasite control. And if there's no other questions, which it doesn't look like there are, we'd love to thank Catherine for doing this talk for us. It was great to meet you, and that was a lot of great information and insight. And we will email everybody in the next day or so and send out the recording for this video and Catherine's information as well if you'd like to contact her or buy her book or if you have any great questions. All right.
Thank you.
Right. Thanks again, Catherine.
Okay.
All
Bye-bye.
right. Everybody have a good night. Good night.